5, 4, 3, 2, 1. Start. The present matter arises out of a disciplinary action initiated against the petitioner, who was serving in a public office for several years without any prior blemish on his record. According to the facts presented before this court, the petitioner was issued a memorandum alleging gross negligence in the discharge of his official duties, which allegedly led to financial loss and administrative delay. The petitioner submitted his reply within the stipulated period, denying all allegations and asserting that he had acted strictly in accordance with the rules and instructions issued by the competent authority. However, without conducting a proper inquiry or granting him a personal hearing, the disciplinary authority proceeded to impose a major penalty upon the petitioner. Aggrieved by the said action, the petitioner approached the appellate authority, which also dismissed his appeal through a non-speaking order, thereby affirming the findings of the disciplinary authority. The petitioner has now challenged the legality and validity of the entire disciplinary proceedings and consequential orders through this writ petition. Learned counsel appearing for the petitioner argued that the entire action taken by the respondents is arbitrary, illegal, and in complete violation of the principles of natural justice. He submitted that the petitioner was never informed about the nature of evidence being relied upon against him, nor was he provided any opportunity to cross-examine the witnesses or place his own evidence in defense. It was further contended that the inquiry officer was not appointed as per the prescribed procedure, and that no inquiry report was furnished to the petitioner prior to the imposition of the penalty. The disciplinary authority merely reproduced the allegations and imposed the punishment without independent application of mind. The learned counsel emphasized that the impugned orders suffer from the vice of non-application of mind, procedural irregularity, and failure to provide a fair hearing. It was also argued that the petitioner's service record has been otherwise unblemished, and the punishment imposed is grossly disproportionate to the alleged misconduct. In support of his contentions, counsel placed reliance on several decisions of constitutional courts which reiterate that any violation of principles of natural justice renders the proceedings vitiated and unenforceable in law. On the contrary, the learned counsel appearing on behalf of the respondents submitted that due procedure was followed at every stage of the proceedings. It was argued that the disciplinary authority had sufficient material to draw a prima facie inference against the petitioner, and that the nature of the misconduct was serious enough to warrant a major penalty. The respondents also contended that the petitioner was provided with an opportunity to explain his conduct and submit a reply to the charges, which he duly availed. The authority considered all submissions and documents before passing the final order. The respondents further contended that the petitioner cannot seek to avoid responsibility on the ground of long service or past conduct when a specific act of negligence or misconduct has been established. According to the respondents, the scope of judicial review in such matters is limited, and the court cannot sit as an appellate authority over the findings of the disciplinary authority unless the same are shown to be perverse or unsupported by evidence. It was submitted that the petitioner was holding a position of trust and responsibility, and even a slight lapse in duty by such an officer can have serious consequences on public administration. Hence, no interference is warranted in exercise of the writ jurisdiction. Upon careful consideration of the submissions made by both parties and after perusal of the documents placed on record, this court is of the considered opinion that the action of the respondents suffers from serious procedural infirmities. It is a settled position of law that any person facing disciplinary action is entitled to a reasonable opportunity to defend himself, which includes the right to know the case against him, the right to cross-examine witnesses, the right to be heard in person, and the right to a reasoned order. In the present case, the petitioner was denied several of these safeguards. The record reveals that no proper inquiry was held, no oral evidence was led, and no inquiry report was ever served upon the petitioner before the penalty was imposed. These omissions amount to a clear violation of the rules of natural justice and render the disciplinary proceedings void ab initio. The appellate authority also failed to discharge its duty by mechanically endorsing the findings of the disciplinary authority without assigning any independent reasons. It is the duty of the appellate authority to examine the entire matter afresh and apply its own mind before arriving at any conclusion. In the absence of such application of mind, the appellate order cannot be sustained in law. This court further notes that the punishment imposed upon the petitioner appears to be disproportionate when viewed in light of the nature of the allegations and the petitioner's overall service record. While it is true that any misconduct must be dealt with firmly, it is equally important that the punishment must fit the gravity of the offense. In this case, the petitioner has served for more than 20 years without any previous charge or warning. The impugned action not only affects his present livelihood but also his pensionary benefits and long-term reputation. The respondents, while exercising their disciplinary powers, are expected to act fairly, reasonably, and in accordance with settled principles of law. Any deviation from such standards cannot be condoned by this court. Therefore, in the interest of justice, the impugned orders are quashed and the matter is remanded to the disciplinary authority for fresh consideration in accordance with law. The authority shall ensure that the petitioner is given full opportunity to present his case and that a speaking order is passed within a reasonable period, preferably within 3 months. It is made clear that this court has not expressed any opinion on the merits of the charges, and the disciplinary authority shall proceed uninfluenced by any observations made herein. Stop.